In a medical malpractice case, is there ever an instance where the doctor will actually admit all of the allegations that you have made in your case? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. I will tell you, I've been in practice more than 29 years now, and I have never, ever seen a doctor or a hospital turn around and admit all of the allegations that an injured patient has made. And there are many reasons for that, but let me give you a few. The very first reason why they will not do that is because if they admit each of the allegations that you have made, now the only issue left to decide is how much are your injuries actually worth. And I will tell you that they fight that issue tooth and nail. They will never, off the bat, admit and accept your number of what your injuries are worth. Every aspect of your claim is actually disputed. You say the doctor violated the basic standards of medical care. The doctor turns around and says, "Why are you suing me? I did nothing wrong." You say that the doctor's carelessness was a cause of your injury. The doctor says, "What are you talking about? Even if I did something wrong, it didn't cause or contribute to your injuries." You say your injuries are significant and permanent. And the doctor again turns around and says, "What are you talking about? Even if I did something wrong and my wrongdoing caused you harm, your injuries really aren't that bad." So they dispute every part of your particular claim. They will never, ever admit all of your claims. Now, another reason why they don't admit it is because if they admit certain things, now other attorneys with similar cases may turn around and say, "Hey, you admitted all these things in Oginski's case. My case is just like yours. You now have to admit all those things." Because now we have set a precedent, or actually the doctor or the insurance company has set a precedent about things that they have now admitted. Yes, we admit that on this day, everything in the hospital was done incorrectly. Okay, so now 10 patients got injured. Guess what? My clients may have been the first case to be litigated. And now comes attorney number 2 and attorney number 3 and attorney number 4. And guess what? They don't want to go ahead and admit in each separate case. They want to fight each and every allegation, hoping that they can get a case thrown out against each and every patient. So, what's another reason? Another reason is if they go ahead and admit the allegations, now they have to have a trial on damages. Unless, of course, the parties can come to an agreement about the value of your injuries. And as I mentioned before, nobody ever really agrees on the value of a patient's injuries at the very beginning. Why not? It's because the defense has no real idea of what the true extent of your injuries are. They need time to go ahead and evaluate the case. They need time to go ahead and obtain your medical records. They need to evaluate the current treatment that you're getting. They need to speak to their own medical experts to determine and evaluate what your problems will be into the future. In all likelihood, they will go ahead and question you at a question and answer session known as a deposition, which really is pretrial testimony given in your lawyer's office. And there are a couple of key reasons why they want to do that. They want to ask you questions under oath. Now, there's no judge present and there's no jury present, but there is a court stenographer there to record all of the attorney's questions and all of your answers. And that carries the same exact weight as if you are testifying at the time of trial. And this does a couple of things. When you give your answers, you're basically locking yourself into an answer. They're asking you questions about what things you can no longer do today, and how is that different from what you used to be able to do before all of this happened, and what things are you no longer able to do into the future, and what things can you do now. So now they go ahead and explore in detail exactly what you can and cannot do. Another reason why the defense does not want to go ahead and admit all the allegations is because they want to show the doctors, they want to show the hospitals that they go ahead and fight vigorously for them with these allegations. And if they were to go ahead and admit at the very beginning of your case that all of these allegations are true, guess what? Now they're seen as, hey, just throwing up their arms every time somebody brings a lawsuit and says, "Yeah, you're right, we screwed up big time, we caused these patients injuries, and now let's just go ahead and figure out how much to pay them." They don't want to be seen as weak to their clients, the doctors, or to the hospitals and the hospital staff. So why do I share this quick information with you? I share it with you because you believe that you have a valid, strong case, and you're thinking, how is it possible that they can defend this case when you know in your heart of hearts and other doctors and other experts have told you that they clearly did something wrong and that wrongdoing caused you significant harm and injury? Well, now you know just a couple of the reasons why. You know, I do understand you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you're thinking about bringing a lawsuit but have not done so yet, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.